paycheck. Even if they still owed you $350, you could not take the lump sum of $350 out of their final paycheck. That is illegal. Okay?
What if they didn't make
Nor
it?
could you hold the check, thank you, nor could you hold the check.
So what happens if I did do something like that?
Right? Right? Well, we would hope that the employee would say, I owed the money, and they would be, you know, a forthright citizen and say, I owed it, it's a clean debt. That's it, but they could take you to the Department of Labor for failure to pay final wages in their effect. So the only thing you could do in that case is take out the regularly scheduled $50 and then ask for the money, you know, from the employees. Can you write me a check? Good luck with that. Yes.
Is this case the same as the Brinker versus Superior Court that's up before the?
No.
different?
No.
We'll talk about that later.
Yes, we will. Okay, so our next slide, we're talking about the 99-cent store. This is Wright versus 99-cent stores. Went to the appellate court. The plaintiff was a cashier. The plaintiff filed a class action lawsuit that said that the store failed to provide suitable seating pursuant to California wage orders, which would allow her to sit. Okay, and this actually was a private attorney's. This is something that was covered under the, what is it, the Private Attorney General. Thank you. Thank you. I always get that one. I never remember that one. And what they're saying is that she actually sued for civil penalties. Originally, the Department of Labor said you couldn't sue for civil penalties in a wage claim. But now they're saying that you actually can in this particular case under the PAGA. All right. So an employer can refuse to hire an employee who tests positive for drugs. So this particular case was Lopez versus Pacific Maritime. This particular employee wanted to be a longshoreman, and when he first applied in 1997, he had an addiction to alcohol and drugs. When he went in to do the pre-employment drug screen, he failed, okay? And so they denied his employment. He went through rehabilitation, and he came back about 12 years later, and he said, I want to reapply, and they turned him down. In this particular case, they said that's perfectly acceptable as long as you have a one-strike rule. Now, Lopez argued that they were in violation of the ADA because as a recovering addict, he has the right to, you know, go through recovery, and you cannot discriminate against him because of that. The appellate court said, no, the employer is not discriminating against you because of your disabling condition. They're saying that it does not matter if you had a disabling condition or not. Anybody who tested positive, so it could be a situation where I, as the applicant, just so happened to have poor timing, went out, drank too much, maybe did some recreational drugs on the weekend, not something, I'm not an addict, I'm not, you know, I don't have an issue, but it was just poor timing on my part. I probably shouldn't have gone to Vegas that weekend, and then I came in and I failed the drug screen. So they were saying that it didn't matter if you were a recovering addict, or if you had an addiction problem, or if it was just, poor timing. We have a one-strike rule, and we will not hire anybody that failed the test the first time. Perfectly acceptable, perfectly legal. There was no discrimination in that particular case, as Luke has alleged. Yes?
Is there any provisions for people who have a medical marijuana?
Medical marijuana. All the time. Again, we've got, that's back in court right now because of the state versus the federal, and that's a sticky subject. As far as drug and alcohol policies are concerned, I'm going to, kind of put you back to the idea of alcohol. Alcohol is not illegal. So if someone had a medical marijuana card, it would not be illegal for them to consume or use marijuana or have marijuana in their system if they had a prescription for it. However, being under the influence of marijuana while at work is still unacceptable, just like any other drug that's prescribed. It could be Vicodin. Your dentist could say, this is probably going to really hurt you. I'm pulling out your wisdom tooth. Here's some Vicodin. They like to pass it out like candy. I don't know what that is. But, Vicodin, OxyContin, any kind of prescribed drug, it falls under the same category. Probably not a good idea to show up at work under the influence of any type of controlled substance. So just make sure that your drug and alcohol policy is a zero tolerance policy, and that your employees understand that if they are going to be, if they are prescribed a controlled substance, that they understand that it's the same thing as showing up to work under the influence of alcohol, you know, if it appears that you are, you know, a little loopy and you're not coherent, you're still going to fall under the same regulations as someone else under the influence of alcohol or an illegal substance. But tricky, tricky, tricky. You do not have to hire someone, by the way, even if they have a prescription for the medical marijuana. You can still deny employment. Okay?
Medical marijuana is not protected.
Right, it's not protected. That's correct. As with any controlled substance at the end of the day, because I mean, people, a lot of times people say, oh, well, I took a Darvocet from my mom because I was in a lot of pain. That's not, that's illegal because it wasn't prescribed to them and it's considered a controlled substance.
But the difference is you could say you can't not hire somebody because of a pre-employment drug test if a drug showed up in their system that was legally prescribed to them.
If it was legally prescribed to them, but if it's not legally
If
prescribed.
it's not legally prescribed, even though medical marijuana is still considered to be a somewhat of a legally prescribed drug, the state of California does not recognize that, and neither does the federal government. So it is still not considered to be a legally prescribed medication.
Okay, so let's move on to arbitration. In this particular case, this was an account executive at Inland Valley Publishing Company. She was fired, and she claimed that the reason she was fired was due to race discrimination and retaliation. The employer had an arbitration agreement and an appendix to the employee handbook. Zullo filed a civil complaint instead of requesting arbitration, and Valley Publishing filed a motion for arbitration. The Court of Appeals said that the arbitration policy was procedurally unconscionable and substantially unconscionable. What that meant was they said that because it was as an appendix to the handbook, their argument was it was in our handbook, there was an appendix, she signed an acknowledgement form that she was going to comply with all of our policies, including the arbitration agreement. They said no, because she wasn't given an opportunity to review that arbitration agreement. She didn't know what she was signing. And in fact, she had to, even though it's perfectly acceptable and was available on the internet, and they were given, and their intranet, the policy was available for her to review. They said, why should an employee have to go and search for something that they're agreeing to? Okay? And so in this particular case, they said, no, you need to make sure that that employee has an opportunity to review. That employee has, it's right in front of them before they sign, and they have an opportunity to discuss that with legal counsel before they agree to it. In this particular case, that did not happen, and so they ruled in favor of the plaintiff. Now, make sure that you, the California court has established the minimum requirements for arbitration agreements with employees and standards, which arbitration agreements can be enforceable in California. So at a minimum, you want to make sure that you pre-dispute the arbitration agreements. You can't not limit the damages to employees who are, or any other thing that they're entitled to receive. The arbitrator must be a neutral party, and the employees cannot be required to pay any more than they would pay for other legal, representation or counsel in that particular case. And like all contracts, again, it must affect the employer and the employee in the same manner. So in this particular case, they said, well, in cases of unlawful or in cases of termination, well, I mean, that's pretty one-sided, isn't it? Because who's doing the terminating? The employer. Where does it say that the employee, if they have, so it was only one-sided in that particular